In this screencast, we'll take a look at the U.S. Supreme Court case of Tennessee v. Garner and how it relates to your Fourth Amendment protection from unreasonable search and seizure. In 1985, the Supreme Court considered the question of whether or not the use of deadly force by a peace officer was a seizure under the Fourth Amendment, and if so, should it be judged by the amendment's reasonableness standard. The story starts about 11 years earlier in Memphis, Tennessee. Police responded to a burglary in progress call. Upon arrival, they saw an individual fleeing out the back door of a house. They gave chase. The person who fled out the back door of the house came to a fence, jumped, and attempted to climb over the fence. At this point, the officers shot and killed him. Now, this seems pretty horrible to us, but the law at the time essentially stated that peace officers could use deadly force to stop a fleeing felon, and the guy who was running from the house was fleeing from a burglary, which was a felony. In fact, the officers testified they didn't think the suspect posed any threat to them, and they were simply complying with what they understood the law to be at the time. The deceased burglary suspect turned out to be a 15-year-old who took a ring and a very small amount of cash from the home. The Supreme Court ruled that whenever an officer restrains the freedom of a person to walk away, he has seized that person. They said, quote, "There can be no question that the application of deadly force is a seizure subject to the reasonableness requirement of the Fourth Amendment." In other words, if a peace officer uses deadly force, they have made a seizure, and their actions are subject to the reasonableness requirement of the Fourth Amendment. Tennessee v. Garner, plus another later court case, has set a standard that whether a peace officer is applying handcuffs or employing deadly force, they have made a seizure under the Fourth Amendment, and therefore their seizure must be reasonable.